entity. When David Chase, the son, was asked to be excluded from everything, including membership in the partnership, even including employment with his father's company. Nonetheless, his father, Dean Chase, permitted him to continue to be involved. He wrote a letter which Silver Peak viewed as impertinent, and Silver Peak called the loan. This is one of these convertible notes where they could have translated this into membership in the partnership. They chose not to do that. This created a crisis and imposed a lot of leadership responsibilities on Dean Chase, who had no interest in it. We get to the fall without getting into all of the other detail. There was a need to try to pay off the Silver Peak loan, which was secured. There was a proposal made by Mr. John Palmer on behalf of the Carroll estate that had various elements in it. It was a proposal by email, and it was discussed. However, there was never a meeting, and that was never voted upon to accept that as the proposal, and no promissory note was prepared or tendered. Unknown to the partnership, Mr. Chase had his wholly owned company, DF Chase, pay off the Silver Peak loan. It was not, the loan was not purchased, it was paid off. There was no note given, there was no vote of the partnership on any of its terms because they were not known or disclosed. When the loan was closed and the property was sold to Silver Peak, to Virgin, Mr. Chase charged roughly $300,000, which had never been previously disclosed to any of the partners or approved on. Partnership agreement.
Mr. Blackman, let me make sure I understand your argument. In regard to the Palmer loan, you said it was discussed but not voted on?
Yes, Your Honor. There were email discussions and such things as, do you want to do this? Others say, well, I think we ought to go with this. There were positive expressions. Now, the appellee has contended it was voted on. The problem with that is that if it were voted on, that should have been the note. That should have been reduced to writing, and that should have been what was dealt with and the source of the money. But that never happened.
Let me ask you, do you dispute that the terms of the Chase loan was better than the terms of the Palmer loan?
We do, Your Honor. We dispute it as a matter of fact, but it was never the subject of discussion because it was concealed. The note didn't exist when the money was advanced. Those terms, you can never go apples to apples to compare them because you didn't have anything to compare it to. One of the important things that later came out was that there could have been 90-day extensions at the option of the borrower. That was very important. It was very important to our proof, having to do with the need to have a 6-month period to market the property and reach its full value.
So you dispute the trial court's finding that the Chase loan had more advantageous terms for the partnership than the Palmer loan?
Yes, Your Honor. We dispute that, beginning with the fact that there really weren't two things to compare. She treated those as though these were two different notes lying side by side and a choice was made, and that didn't happen. So you can't compare a $200,000 downstroke or fee, which worked to the advantage of Mr. Chase, who had a fiduciary duty, which was never disclosed, and compare that to a disclosed term by Mr. Palmer. So even also one of their.
So when do you say you determined that there was a $200 downstroke on this loan?
That was revealed when they started to distribute the money after the closing of the sale. There was a demand by Mr. King for books and records. And one of the problems you had here was that they had never set up, as the partnership agreement required, two separate accounts. You only had one single commingled account. So discovering this type of information was frustrating.
So what was your client's understanding of this bridge loan, or whatever you want to call it?
Well, he received an email from David Chase, Dean Chase's son, saying that his dad was going to, quote, stroke a check, end quote. Dean Chase had said that he would be willing to lend the money or cause his business to lend the money to give them more time for the sale. When Mr. John O. King was his nickname, when he pointed this out to Mr. Chase's response was, "I lied." Now that may have been jocular, but he never denied saying it, but he did say the words, "I lied," about that. So he thought there was going to be some sort of loan that would allow them additional time properly to market the property. And that,
Loan from whom?
pardon?
Who was the loan going to be made by?
Well, Dean Chase's loan was made by his company, DF Chase, who was a partner.
Yeah, I understand that's, I assume what you're saying is what happened, but what I'm trying to understand what your client's perception of this was, according to the evidence.
Well, his perception was he was willing to proceed with what we've called the Palmer loan, which was the Carroll estate. However, the money was advanced from DF Chase without anyone's knowledge until after the fact. They made
Well, what did you think had happened?
He thought that DF Chase had stroked a check. That's what his son told him. And
so, I mean, obviously we're talking about a pretty good chunk of money here. So, I mean, there had to be some kind of understanding, agreement, or something.
Well, I hear Your Honor. I agree with Your Honor, but there wasn't. He did it without the consulting with the partners. In fact, the partnership agreement required that any interest that was paid to a partner had to be approved by the partnership themselves. That was never done. So the partnership agreement was violated. He had become.
Yeah, one more question. So this was made, this loan was made, and then how long was it between the time the loan was made and the property sold?
I want to say the loan was in late September. The sale of the property was closed in early December, sometime in December. The closing itself with the distribution of the money was, I want to say the 20th, 23rd, something like that of December.
And your client just assumed what, that this was, that the Chase company had just advanced the money to keep the project running?
Well, he was told that it was going to be advanced by DF Chase for the purpose of allowing additional time to market the property. And then Dean Chase said that he couldn't do that. And the reason he couldn't do it is because his construction company couldn't carry this on its books consistent with his needs to have a bonding and construction loans, legitimate reasons, but reasons not involved in the interest of this partnership, solely for the interest of DF Chase, which was a part.
Let me ask you.
I'm sorry, go ahead.
No,
If Chase had not made the loan and paid off Silver Peak, would the property have been foreclosed on in a matter of days?
Well, I think that's reasonable to be concerned about, but we'll never know, because the Palmer loan could have been closed also. The purpose of the Palmer loan was to prevent just that. So we won't know. So the appellees have taken the position the Palmer loan was voted on. We respectfully disagree with that, but if it had been, that should have been the loan. That's what should have been closed. And they knew all the terms of that and were willing to have a vote and approve of it. Dean Chase directed this to DF Chase when he knew that there was an alternative present. Their excuse was that the interest rate may have been usurious. Well, we'll never know that either. the Carroll loan, Palmer loan, would have been funded out of Florida, which has a different usury statute from our own. So that's all in the nature of excuse making. But he took at least $300,000 to his company that otherwise he would not have received. That's the problem. Running out of time, we have so many issues that we've raised that we can't get to, but I do want to make sure one thing is clear. Dean Chase was never a partner, and he was never a member of the LLC.
Well, let me ask you this before your time ends. In your lawsuit against him, you actually state in your complaint that he was a managing partner. But more importantly, you brought breach of fiduciary duty claims against Mr. Chase. If he's not an officer of the LLC, not an employee of the LLC, not a manager of the LLC, what would be the source of or the basis for a breach of a fiduciary obligation?
Well, Your Honor, the way that evolved was that when David Chase was removed from the project, they amended the partnership agreement and said that Dean Chase was managing. He was going to have the term managing partner. They substituted his name in there for David. However, he never purchased any interest or invested in it, but he was designated the managing partner by a document signed by all of the partners. We allege that he was not a partner. The defendants admitted that, and the chancellor found that he was not a partner, but he was the manager. He was the managing partner. The only member of the LLC was the partnership. And Dean Chase was never, this all came in the context of this indemnification argument. And if you look at the statute, which both sides have referred to, the statute refers to responsible parties and then gives a definition of who the responsible parties were. And Dean Chase never fit within any of those categories. And for indemnification, the statute says, nonetheless, the board or the managers would have to review the request for indemnification, which never happened. So there was no basis for indemnification. And finally, Mr. Chase is the one who sued the partnership and the LLC. The case against the partnership was dismissed, and the one against the LLC was never defended. He had the ability, and we would suggest the duty, to hire an attorney to raise these defenses on behalf of the LLC, and he never did that. That's what I referred to in the brief as taking the bat out of their hands and calling them out on strikes.
All right. Any other questions? Either of the members of the panel? All right. We will hear from the appellate.
Your Honors, thank you for the time today. Charles Malone, my law partner, Bo Creason, is here but not on camera, and we represent the appellees Dean Chase and D.F. Chase. Mr. Blackburn and I do agree that there are a lot of issues on appeal, so I will try to address what he has raised in his argument because the amount of time will not permit us to address them all. I think one of the major points that we believe the court should highly consider and take a very critical eye to these briefs on is Tennessee law, which is clear-cut that any appeal has to be grounded in the actual record and has to include arguments that are more than bald assertions of error. And the Kings in this case violate both of those principles repeatedly and have done so in this argument themselves. The record on summary judgment, which we can start there, in their brief, their appellate brief, the Kings cite to their second amended complaint as grounds for their disputes of fact on summary judgment. Well, allegations in a complaint do not create disputes of fact. You have to prove them, which is why we had 2 years of litigation, and the Kings utterly failed to prove these allegations. Another example is Mr. Blackburn, on behalf of the Kings, just argued that summary judgment was inappropriate on one grounds because the Kings and the partners never voted to approve the Palmer loan under the financial terms and conditions that had been proposed by the Carroll estate. If you will refer to the technical record, volume 11, at 1488 and 1489, which is the King's response to the Chase's statement of undisputed material facts, they state it is undisputed that, quote, the partners, including the Kings, voted to approve taking a loan under the financial terms that have been proposed in the Carroll estate's offer. So the context of all this is Silver Peak was going to foreclose, and the Carroll estate, they could not get a traditional loan from a bank, and the Carroll estate said that it would lend the money with a $100,000 origination fee, 15% annual interest, 3-month term with 3-month extension fees, foreclosure fees, and the partner said, let's do it. The Kings also admit on summary judgment that the attorney for the NV entities advised Mr. Chase as manager that the 15% interest rate proposed by the Carroll estate was usurious and illegal. At that point, on the day before foreclosure, Mr. Chase did stroke a check in terms of writing a loan of $6.3 million under terms that were more favorable than the Palmer loan and were legal, as advised by the lawyer. Now, it was our position in this.
Let me ask you, I've been trying to figure out the math that makes the Chase loan better than the Palmer loan. In the Chase loan, there's a $200,000 origination fee. In the Palmer loan, it's only $100,000, and that's for a 3-month period. And the property closed, the sale closed within 3 months. What makes the Chase loan better? Because if you add interest to the $100,000, even if it was interest for a year at 15%, that would only be $90,000. So you got $90,000 plus 100, that's 190. But actually, you'd only be looking at interest for a quarter, which is more like 20,000. So the Palmer loan is 120, but at the outset, the Chase loan is 200,000. So I don't understand the numbers. Why the Chase loan was better?
Well, Your Honor, I will have to confess that I can't do the math in my head as quickly. We had an expert that was disclosed, Chris Lovin, that ran that math exactly for the exact period of time. And the DF Chase loan was $37,744 less expensive than the terms that had been proposed by the Carroll estate and approved by the partners. That was an undisputed material fact that the Kings admitted. They admitted it. Now, Mr. Blackburn said,
and we find that admission where? Where do we find that admission?
That admission is at volume 11, page 1490. I don't know the number of the fact, but it's in their responses to Dean Chase's statement of undisputed material facts in support of his motion for summary judgment. The one issue they do raise is they admit that it was $37,000 cheaper, but the Kings say, but the Palmer loan would have had the attorney's fees to draft the paper included, and the Chase loan did not. And the trial court said, just raising that issue as a lawyer argument does not create a disputed material fact. The plaintiffs, the Kings, would have to come forth with evidence that those attorney's fees would have been more than $37,000, thus making the Chase loan more expensive as opposed to less expensive. And, one issue that gets brushed over by Mr. Blackburn on behalf of the Kings is, yes, Mr. Chase did make the loan and did receive interest and a fee for that, but it was to save the partnership. If Palmer had made the loan, that money would have gone to Palmer. There was no damage to the Kings as long as it was equal to or less money. And it was our position throughout the litigation that we would prove at trial that there was nothing wrong with Mr. Chase and DF Chase making this loan. In fact, it was a very magnanimous gesture to the partnership to save the entire project. But we didn't have to go do that and the expense of a trial, because we could disprove an affirmative required element of their claim, which is damages. And the facts are undisputed. The Kings do not dispute them, and they are listed actually in our brief, but they're also in the record at volume 11 under this statement. So the Kings, the one other issue that was discussed at some point, and I think it was a question to Mr. Blackburn, was what was the King's view of what would happen? The evidence in the record is all over the map on what the King's view was. They ultimately did say that it was a loan, that the Chases would have given a loan, or Dean Chases would have been a loan. One of the Kings, however, said it would have been equity, which would have been far worse for all of the partners if he'd taken an equity stake in the project. And so this is just, the summary judgment is entirely proper based on the undisputed facts in the record. And the Kings, while they have a lot of lawyer argument in their brief and assertions of fact, they're not found in the record. The argument is not correct, and the assertions of fact are nothing but fanciful allegations that not only weren't proven, they were proven to be false throughout discovery. The second thing I'd like to address briefly, with the remainder of my time, unless the court has any questions on other issues that are out there, is this indemnity argument that we closed the last part of the argument, Mr. Blackburn's argument with. And Mr. Chase was asked to be by the partners and elected the manager of the partnership. He took the place of the managing partner. He was the individual responsible to take actions for and on behalf of the partnership. And the partnership was the sole member of the LLC. And so Mr. Chase had to act on behalf of both entities. Ultimately, Mr. Chase caused the LLC to sell this property to Virgin for $11 million. He did that pursuant to a unanimous consent of all partners, including the Kings, directing him to do it. His fiduciary obligation was to sell the property. If he had not done it, if he'd refused to follow the directive in the unanimous consent, that is where he would expose himself to legal liability. And then after he sold the property as directed by the partners and distributed the money, because he was sued by the Kings. And in that, Mr. Chase, in his role of those two, with the partnership and the LLC, is entitled to indemnity under the law if he can prevail in that lawsuit. Now, the Kings make devote a large portion of their argument to Mr. Chase was not a responsible person as defined by the statute. He was not. But the statute provides, in relevant part, which we have stated from the start, that Mr. Chase, and I'm going to give you the exact quote of the statute here, and I apologize for having to look down at my notes. TCA 48-249-115G provides that an officer who is not a responsible person is entitled to the same mandatory indemnity and the same court-ordered indemnity as a responsible person under the revised act. An officer is defined as anyone who has delegated the rights and the powers to manage and control the affairs of the LLC, whether that person is a member of the LLC or not. So it is a red herring for the Kings to continue to write in their brief and to continue to argue in front of you that Mr. Chase is not entitled to indemnity because does not meet the definition of a responsible person under the statute. Mr. Chase has never argued he met that definition. The sole basis for indemnity and the basis the court awarded indemnity on is that Mr. Chase was an officer of the LLC being sued for actions he took in that role. And so the indemnity award is based on the undisputed facts in the record. It is based on the first amended counterclaim, where the Kings admitted the operating agreement, they admitted the partnership agreement, they admitted the corporate structure, and they admitted the unanimous consent directing Mr. Chase to sell the property. Once they did that and they sued Mr. Chase for it, when he prevailed on summary judgment, he was entitled to indemnity as a matter of law under the Tennessee statutes. So that is the indemnity issue. I noticed I have 3 minutes left. We have about 20 to 30 appellate issues that have been briefed by the parties. I don't have any specific ones that I've been focused on addressing. If the court has any questions, I would be happy to answer them. If not, I'll cede my time and rely on our briefs.
Let me ask you, Mr. Malone, if Mr. Chase had sought an assignment of the Silver Peak obligation and position where he could convert, if he paid them off, and assume a position where he could be an equity owner, would he have been in a better position and obtain more money by the sale as opposed to less money? You understand what I'm asking? Because
I
Silver
do
Peak
understand.
could convert its loan to an equity interest. And as I understand it, that equity interest would have been as much as 75% ownership of the LLC. And then upon the sale, what would Silver Peak have been paid? Have you thought about that at all?
We have thought about that, Your Honor, and that was part of our experts' disclosure and report. And the gist is, if Mr. Chase and DF Chase had obtained an equity position equal to the $6.3 million that they paid off, they would have become the vast majority owner of this project, of this partnership. And they would have received, and I don't have the numbers in front of me, it is in the record, it's part of the summary judgment. It has not been focused on by the Kings, but they would have received the vast majority of all proceeds. I can only say this way, is that it would have been a terrible result for all the other partners, because they would have gone from, the Kings, I would say, would have gone from owning 11 or 15% collectively of the partnership to a minuscule fraction of a percentage, because the partners themselves, I believe, raised $3 million total at the start of the project. Mr. Chase had a large portion of that, or DF Chase had a large portion of that. And then it would have taken the $3 million to $6 million to $9 million total, over $9 million total, where DF Chase had, I believe, over $7 million of that interest. So doing the math off would be about 75%. And 75% of $11 million is, my math is terrible, but $8 million that he would have received, as opposed to $400,000 on the loan.
Any
Does that
other
answer
questions
your question?
Yes.
for Mr. Malone?
No.
Okay,
Apology.
thank you, Mr. Malone. We'll hear from Mr. Blackburn in rebuttal.
Mr. Malone has said that the matter was admitted, that one was more expensive than the other as to these two. Request for admission number 13 is contained on page 1490 of the transcript. It says the DF Chase loan was $37,744 less expensive than the terms, etc. Answer to that is disputed. And then it mentions that the Palmer loan did include attorney's fees. The Chase loan did not. Of course, that was never disclosed.
Let me ask you, Mr. Blackburn, if Mr. Chase was acting in his own interest in connection with this transaction, why would he not have done what I just suggested, which really would have been the smart thing to do? He could have bought the Silver Peak loan and his equity ownership would have been about 75%. And of that $11 million, he would have gotten $8 million, just not, a 30% return on what he invested. And your client would have gotten substantially less than what they got. Is that true?
Well, if we start with the initial assumption, and I'm not certain this is in the record, but I doubt Mr. Malone will disagree with this. Silver Peak refused to do that. They were never willing.
No. Well, yeah, they refused to convert to an equity ownership. They wanted their loan repaid.
Well,
Mr. Chase could have had that loan assigned to him and also assumed an equity position.
But Silver Peak refused to do that.
Refused to do what?
Convey the note, negotiate the instrument.
Is that in the record?
It was not discussed in the trial court, but it certainly was discussed by in all the discovery. I don't think the notion that he could have done that is anywhere in this record, and I know that it was not done. It was not available to him. It couldn't be done because, see, Palmer could have sought the same thing. He could have negotiated the same thing on behalf of the Carroll estate. So that never happened. The chancellor just made an apples to apples comparison between these two, and did not consider the fact that this partnership agreement itself forbade interest being paid to a partner without the vote of the partnership, and that never happened. So if you take this roughly $100,000 worth of interest that was charged alone, that makes it different. And then depending on how one construes the $200,000 downstroke commitment fee, if you look at what was lawful, there is no comparison. Palmer loan was completely disclosed, and the Chase loan was not. In fact, it was only revealed when people started asking questions about how they were distributing the money. That came up at first in the context of Chase having said they'd have a 39% return. It turned out to be 31% return on their investments. But as to the indemnity, the statute is clear. What he's talking about is mandatory indemnification. And if you look at the definitions of responsible person, he doesn't meet any of those. I'm not aware of any vote taken by the membership of the LLC to this effect. And even if they had, even if that were true in terms of mandatory indemnification, there was an additional step by statute, and that was they had to say that he had done nothing wrong. They had to affirm that his behavior was not wrong.
You're out of time, Mr. Blackburn.
Oh, yes. Thank you, Your Honor.
Yes, sir.
Sure.
All right, gentlemen, we appreciate your argument. We'll attempt to get you an opinion, hopefully resolving this issue, or at least at this level, as much as we can. Again, we appreciate your participation. Mr. Hibner, if you will recess the court to the call of the next case.
This honorable court is now in recess until 1 p.m.
Thank you.